Hi guys, it's Kathy. I hope you're doing well. Today I have a humzinger of an attorney in big trouble. So we're going to Connecticut, and we don't have an ending. We just have a hearing of them presenting evidence against this attorney who's in big trouble. The judge, we won't see the next hearing. I'm just warning you now. We won't see the next hearing in this case because the judge makes it in person. So, but we do get to hear the attorney, and we get to hear some of the people who have issues with this attorney. And he's great. He is an attorney. I know some of you think that he will be like pro se trying to be an attorney. As of right now, he's still an attorney. I'm sure in the future we'll see him as pro se subset, maybe. I don't know. But for right now, he's an attorney with lots and lots and lots of issues. So let's go to Connecticut.
Looks like we're all set.
We
All
are on
right,
the record, Your Honor.
we're back on the record. Mr. Hikes, have you been able to take that photograph and text it to Mr. Ferraro?
That is affirmative, Your Honor.
Okay, and Mr. Ferraro, you've received it?
Yes, I have, Your Honor.
Okay, all right. All right, Ms. Villar, you ready to proceed?
I am, Your Honor, and as a housekeeping matter, the Office of Chief Disciplinary Counsel has filed 13 exhibits, and I move to make them all full exhibits at this time.
All right, would you like to be heard on that, Mr. Hikes?
Your Honor, just a matter of housekeeping. Could I just be heard briefly?
Well, you can be heard with respect to the offer that's just been made by Ms. Villar to admit the exhibits that have all previously been marked for identification. If you have no objection, I will mark those all as full exhibits.
He's
Well,
going to
Your
be
Honor,
heard.
I don't know what exhibits she's talking about. I have some paperwork here with a couple counts that I have never seen, so I would object.
And the basis of your objection is that you haven't seen them?
That is, to the best of my knowledge, what I'm having here is the summons and the complaint.
Yeah. It's my understanding that the list of exhibits is in the court file. It's been there since September 23rd. And go ahead.
I'm sorry, Your Honor. This is why, due to extenuating circumstances I'd like to bring to the court's attention, I've just gone through 4 family deaths in the past 3 months. I have the funeral things that I have gone to. It has been a very trying time for my family. I would be asking for a 1-month continuance, and there's other too. Well, and say, I'm just not in a really good spot right now, Your Honor.
Well, I want to be sensitive to that, Mr. Hikes, but I'll note that this presentment was filed on August 2nd. There have been certain efforts taken by the Office of Chief Disciplinary Counsel to reach you, to get you to file the matter. Certainly, had you filed an appearance in the matter or appeared in some way or communicated in some way with the Office of Chief Disciplinary Counsel, I'm sure that they would have attempted to accommodate you. But now the matter has been down for quite some time. It's been scheduled for this hearing for quite some time. Witnesses are in place. The Chief Disciplinary Counsel is ready to proceed. You want to be heard, Ms. Villar, with respect to Mr. Hike's request?
Just to reiterate what you've said, Your Honor, Mr. Hikes knows how to contact me. I have not heard from him via email or via telephone. He did not appear at the status conference. I attempted to contact him through the last email that he sent to me, where he sent communications to me, and that was May 8th, 2024. That bounced back as non-deliverable. I attempted to call his cell phone number, which I had been in communications with him up until that May 8th date. That has been discontinued, or it's not in service. I have made every attempt to contact Mr. Hikes, and he knew how to contact me, Your Honor. At no point in time did he ever contact me and say, I need a continuance. I can't go forward. I can't show up at the status conference. I can't go forward at the hearing. Had he had done that, Your Honor, of course I would have no objection to a brief continuance. But as Your Honor said, I'm here now, ready, willing, and able to go forward. I have my two witnesses who've taken time out of their schedule and away from work and away from other obligations to be here today, and I'm ready to go forward.
All right, Mr. Hikes?
Thank you, Your Honor. It's very trying. The woman I've loved most, my grandmother, the only reason I went to law school is because of her. I nearly eat breakfast with every morning, died suddenly. In addition, with the other family members, I have been before a few medical experts. They formed an opinion I am not fit to be in a trial at this particular moment. I would consider that from a medical professional's opinions. Your Honor, the state, after my grandmother passed, her passing was June 14th of 2024. In the Kennedy Hill address, the bar, on its own volition, in my absence and my uncle's, because it's his house now, according to the will, the bar, while we're grieving, they trespassed on my grandmother's property, my uncle's property, walked right past the no trespassing sign, probably about 30 feet or so from the main window overseas, and then proceeded to duct tape this paperwork of the presentment here to the window, which was extremely humiliating for all the neighbors got to see and everything. It made my uncle nearly lose his mind. I'd be willing, he's willing to testify that's what he personally witnessed. Your Honor, he had to use a razor to get the tape and the thing off of it. Thought it was a condemnation, the house. He didn't know what was going on. And it really just after my grandmother passed, and then for my dead woman's house, they're desecrating. It really put me in a mental state, amongst other things, that the bar has been engaged in. That maybe the court would be willing to hear me.
Well,
If I may, Your Honor,
yes.
Service was made at Mr. Hike's last registered abode as he registered with the statewide grievance committee. A process serving company in Pennsylvania was hired because that is where Mr. Hikes lives. And it was served according to their rules. I will note that 3 separate attempts were made at 3 separate times of day by knocking on the door, ringing the doorbell. Nobody answered, nobody came forward, and the presentment was left as abode service.
All right. Well, I think I've heard enough on that issue. I understand your respective positions with respect to that. Mr. Hikes, I'm still left wondering why you didn't just pick up the phone and call the Office of Chief Disciplinary Counsel to explain this predicament in which you now find yourself. But these are very important matters to the people of the state of Connecticut, attorney disciplinary matters. They need to be handled in a quick and timely fashion. Ample notice has been given. You've already indicated that you received the service of process. Your uncle used a razor blade to remove them.
But Your Honor, they taped something to my front door. I can't possibly go forward. Do you know how hard that was for me?
From a window, you just held them up, showing me that you did receive them. So, upon the conclusion of the state's case, I may grant you some relief to provide a defense if you want to do that. But I think at this point, I'm going to deny your request for a continuance. I'm going to overrule your objection to the admission of the exhibits, which have been on file in the court record for anyone to review. So the continuance request is denied. The exhibits that have previously been filed for identification are all marked as full exhibit, and exhibits in Ms. Villar, you may go forward.
Yes, Your Honor. So my plan is, as you can see, it is a 2-count presentment. I'll just wait for the siren. It's a 2-count presentment, and my plan is to do each count separately. So we'll start with count 1, and I pull William Morales.
Your Honor, at this time, may I make a motion?
Yes, sir.
Your Honor, pursuant to res judicata, I ask that this matter has been previously litigated. I had a hearing on there, and here we are over the same things. Beyond this, Attorney Hardy was grieved over the same essential allegations, a black attorney, and his matter was dismissed, but yet a white attorney. It is here going forward. I ask for a dismissal.
You crazy.
Ms. Fly.
Yes, Your Honor, this matter did go before a grievance reviewing committee of the statewide grievance committee. And in their decisions, both of their decisions, which are now full exhibits, you will see that the Office of Chief Disciplinary Counsel was directed to file presentments in both cases, Morales versus Hikes and Capellas versus Hikes, as a trial de novo. This is not res judicata, and I still plan on going forward.
The motion to dismiss is denied. You may go forward.
If we could have Mr. Morales sworn in, please.
Mr. Morales, please raise your right hand. You solemnly swear or sincerely affirm that the evidence you shall give concerning this case
I
shall be
can't
the
believe that
truth,
didn't
the
work.
whole truth, and nothing but the truth. So help you God, or upon penalty of perjury.
I do.
Thank you. Can you please state your name, slowly spelling your last name for the record and the town in which you live?
William, last name is Morales, Morales. I live in New Jersey.
Thank you.
All right, you may proceed.
Thank you, Your Honor. Mr. Morales, how did you come to hire Corey Hikes?
My wife hired James Hardy Law Group, and Corey Hikes was the attorney that Mr. Hardy sent to cover my case.
Do you have all the exhibits in front of you that I filed?
Yes, I do.
So drawing your attention to Exhibit 2, can you please tell the court what this document is?
This is the fee agreement that I had with attorney James Hardy, and on the second page, it lists the other attorneys who may work on this case as well.
And is Corey Hikes' name on there?
That is correct, and so is Elizabeth Roback, Andrew Kao.
And on what dates did James Hardy send Corey Hikes to represent you, if you remember?
There were 4 dates, October 7th, 2021, March 25th, 2022, May 19th, 2022, and August 26th, 2022.
And which court did he go to represent you in?
The Waterbury Superior Courthouse.
And in what prior cases did Mr. Hikes represent you?
None.
Did you have a separate fee agreement with Mr. Hikes, separate than that with Mr. Hardy?
No.
And what type of case was Mr. Hikes supposed to represent you in?
Criminal defense.
And did you go to his office before meeting with him?
No, I never went to Hardy or Hike's office.
Why not?
Every time we met inside the courthouse or outside the courthouse.
And when was the first time that you met with Corey Hikes at court?
It was October 7th, 2021.
And how did you know that you were going to be meeting with Corey Hikes and not James Hardy?
I didn't find out I was being represented by Corey Hikes until James Hardy sent me a text message informing me to reach out to Corey Hikes.
And if we look at Exhibit 3, are those your text messages to and from James Hardy?
Yes, it is.
Drawing your attention to Exhibit 4, can you please tell the court what this is?
Your Honor, I have no idea what Exhibit 4 is because I don't have possession of them nor received a copy, nor did I get any discovery. They won't give me anything, Your Honor. I've tried this before. They don't give me any prior, similarly situated cases. I mean, I can't even formulate a logical defense with not being provided anything that my previous counsel, Josephine Miller, has attempted to get myself. I mean, Your Honor, the other thing is too, is maybe you might want to inquire to the bar. Has Attorney Villar ever called me on my personal cell phone and spoke to me in regards to the previous matter when Josephine Miller was my attorney of record, ex parte communication? I looked it up that day on judicial, and it put me in a mental state. And the way I interpret it was taunting, harassment, and spitefulness is what I interpreted, Your Honor.
She
I wish
probably
her
said
phone
hi.
records would corroborate that.
Your
Mr.
Honor,
Heights, go ahead.
Your Honor, I attempted to call Mr. Hikes at the last cell phone number that he gave me, and that number has been disconnected. I attempted to contact him via email at that last email address that he and I had communications, and that bounced back as non-deliverable. I then attempted with 3 other emails that my investigator found to contact him, urging him to contact me at his earliest convenience. Had he done so, I would have sent him all the exhibits and anything else that he wanted. I certainly wasn't going to send exhibits in a disciplinary proceeding to an email where I didn't know where it was being received. In no way, shape, or form have I ever harassed Mr. Hikes.
Your Honor, part of the reason for a number being done is because my grandmother died, and she was a former accountant and such. She handles a lot of affairs, but since her passing, the phones had to be shut off. I mean, things are in probate. It's been a real mess, Your Honor.
Mr. Heights, it just seems to me could very easily have been resolved with a simple phone call to the Office of Chief Disciplinary Counsel. That phone number hasn't changed. That office location hasn't changed. That email address hasn't changed. It's the one constant. I know you're attempting to shift the burden of responsibility here to the Office of Chief Disciplinary Counsel when the responsibility rests with you here. So you're I'm not exactly sure what your request is. It seems like, again, you're requesting that the matter not go forward today because you don't have access to the exhibits. But I'm going to deny that request.
Thank you, Your Honor.
Your Honor, I would also like to tell the court that these exhibits were part of the underlying grievance, and Mr. Hikes has copies of these exhibits from the underlying grievance.
Mm.
So going back to exhibit number 4, Mr. Morales, can you please tell the court what exhibit 4 is?
This is my cell phone call detail, which shows the number I called on October 7, 2021, and the location pin of where each phone call was made on that date.
And looking at October 7th, 2021 at 9:32 a.m., whose number is 814-720-0713?
That was Corey Hike.
And how do you know it was his number?
It's the number that Attorney James Hardy gave me through text to contact his colleague,
Just so you know, I didn't dox him right there. That phone is gone now. It's been shut off. He doesn't have it anymore.
Attorney Hikes.
So
At the above number.
if you were in court, why did you have to call Corey Hikes?
I was inside the courthouse first floor waiting for Attorney James Hardy to arrive. And that's when I received a text message from Attorney James Hardy to contact his colleague, Attorney Hikes, because due to a scheduling conflict.
Okay, and what transpired in the texts?
Well, in the text, James Hardy told me to contact Attorney Hikes, in which I did. I spoke to Attorney Hikes at 9:32 a.m. We spoke for about a minute. I went outside the courthouse to meet with him.
Why did you go outside the courthouse?
Because that's where Corey Hikes was
Drug deal.
at.
And where did you meet with him exactly?
I met him outside the courthouse steps.
At the
And
bar next
do
door.
you know what time it was that you first met with him?
At approximately 9:34 in the morning.
And when did you go into the courthouse with Mr. Hikes?
I never set foot inside the courthouse with Mr. Hikes.
What, if anything, did you speak to him about outside the courthouse regarding your expectations?
That I wanted the full discovery evidence in my case so I can make an informed decision.
An informed decision about what specifically?
Whether or not to withdraw from the AR program, since Attorney Hardy told me that this would be the fastest way in getting discovery in my case.
When exactly did you apply for AR?
August 12th, 2021.
And James Hardy represented you when you applied for this, is that correct?
That is correct.
So when you told Mr. Hikes what you wanted him to do, what your expectations were, what was his response on October 7th, 2021?
That he would get me the discovery from me.
And did he go, or did, if you know, was anything put on the record October 7th, 2021?
Nothing happened in court. Mr. Hike was going to the clerk's office to get a continuous date. Like I said, everything took place outside the courthouse steps.
So on October 7th, 2021, can you please tell the court what your understanding was of what Mr. Hikes was supposed to do for you?
He was going to go to the court clerk and change the court date, and he was going to get me the full discovery and evidence in my case as soon as possible.
And what, if anything, did Mr. Hikes tell you about how long it would take to get your discovery?
That was never mentioned.
What, if anything, did he tell you on October 7th, 2021 about the cost of obtaining discovery?
Again, that was never discussed.
And if you could please tell the court about how much time did you spend with Corey Hikes at court that day?
Less than 10 minutes.
What, if anything, did you do after you were done speaking with Mr. Hikes?
I texted Attorney James Hardy from the courthouse parking garage that I was going to leave.
When did you leave?
I left at 9:40 a.m.
And how do you know you left at 9:40 a.m.?
Because it was the text message I sent him, and right as soon as I sent him the text message to James Hardy, I left.
I want to draw your attention to Exhibit 5. Can you please tell the court what this is?
It's an affidavit, Corey Hikes, that he submitted in my grievance complaint against Attorney James Hardy.
And where did you get this affidavit?
It was sent to me from the statewide grievance committee as part of James Hardy's answer to the grievance.
All right, so I want you, and you have that in front of you, Mr. Morales?
Yes, I do.
All right, so if you could just look at that, and I'd like to draw your
Guess who doesn't have it in front of him? Mr. Hicks.
attention to paragraph 5 of that exhibit. Do you see it?
Yes, I do.
So if we look at paragraph 5 in Mr. Hikes' sworn affidavit, it said that he spent a total of 3 hours in court that day. Did Mr. Hikes spend 3 hours with you in court that day?
No, he did not. And if you look at the text messages in my complaint, I text James Hardy that I was leaving at 9:40 a.m. And then if you look at my cell phone call records, an hour and a half goes by and I text James, after I text James Hardy, I was already in Montebello, New York at 11:08.
Shots fired.
Mr. Hikes also claims in his sworn affidavit, paragraph 5, that he reviewed the state's physical file with you and read each line of the police report to you. Did he bring those outside?
Like I said, I was never inside the courthouse with Mr. Hikes on October 7, 2021.
Right.
And I never reviewed anything with him. We just discussed the case on the courthouse steps with regards to my discovery and evidence in my case. Unless he's making the claim that that he was in the passenger seat with me as I was driving back home to New Jersey.
Okay.
I have to know.
Was he in the
Guys, right here. Do you think that's his law degree? Or do you think that's a picture? Or is he in a hotel and that's the fire exit plans?
Car with you?
No, he was not.
So then is it your testimony that you didn't review anything with him that day?
Like I stated, I never reviewed the state physical file, and I would find that it would probably be illegal to take state file outside the courthouse.
In paragraph 6, Mr.
Information,
Hikes. What was that?
objection, volunteering information. I'd ask that comments be stricken, that he volunteered.
I don't understand the objection.
The rules of evidence do not allow a witness to volunteer information. It has to be elicited through a question, is my understanding of the rules of evidence.
Judge Carroll, you're muted.
I'm sorry. He was responding to the question. The objection's overruled.
Mr. Morales, in paragraph 6 of the same affidavit, Mr. Hikes states that you admitted the facts in the police report were accurate. Do you recall making that statement to Mr. Hikes?
Again, I never reviewed the police report with him at any time on October 7, 2001. So this is false on his face.
Did Mr. Hikes represent you, or was he supposed to represent you in court other than those 4 dates that you previously stated?
Yes, on July 27, 2022.
And did he represent you in court that day?
I had court that day, but he was a no-show, and neither was James Hardy. And there was also another client waiting for him as well.
And what did you do when Mr. Hikes did not show up to represent you in court?
I text James Hardy.
Did Mr. Hikes represent you any other date?
Yes.
And why don't you tell the court, what was the final date he represented you in court?
August 26, 2022.
Between October 7th, 2021 and August 26, 2022, how often did Corey Hikes follow up with you regarding the continuances?
Never.
How often did he follow up with you regarding the status of your case?
Never.
How often did he follow up with you regarding your discovery requests?
Never.
What happened in court on August 26, 2022?
I already had a letter written up to fire them both. And because I was tired of the procrastination between James Hardy and Corey Hikes about getting me the discovery and evidence in my case. And since July 27, 2022, I knew I was going nowhere with these guys. So it was best I fire them and hire myself a new attorney.
And I would like to draw your attention to Exhibit 6. Can you please tell the court what that document is?
It's a letter. It's a discharge letter.
It's a letter.
Okay, where you're terminating their employment for you?
That is correct. I fired both attorney James Hardy and Corey Hikes.
And what, if anything, did you do next?
I filed a grievance complaint against Corey Hikes
Why?
because Mr. Hikes failed and provided me with the full discovery and evidence in my case. He also failed and provided me with any updates with regards to my case. And plus he failed to show up on July 27, 2022.
And
Yeah,
was
that's
there
a big
a
one.
hearing on the underlying grievance, if you remember?
Yes.
And did you appear and testify?
Yes.
And did Corey Hikes appear?
Yes, he did.
Did he testify?
He pled the fifth.
Drawing your attention to exhibit number 7, can you please tell the court what that is?
This is the decision of the grievance hearing that was sent to me, which shows the reviewing committee concludes by clear and convincing evidence that the respondent engaged in misconduct.
And did you hire a new attorney to represent you in your criminal case?
Yes, I did. The Sills Law Firm.
And can you please tell the court what's the ultimate result of that case?
My case was dismissed.
I have nothing further of Mr. Morales, Your Honor. You're muted.
Yeah, I apologize. Mr. Hikes, you have any questions of this witness?
Yes, Your Honor. May I inquire to the state, pursuant to prior inconsistent statement? I think it's been done before. Would the state be willing to agree to the transcript of the aforementioned hearing be admitted as a full exhibit and give me an opportunity to copy it and submit it, or the state may be in a possession of it as well?
I'm assuming when you say the state, you mean disciplinary counsel.
That's correct. Forgive me.
Your Honor, I don't have a copy of the transcript, and it was not submitted, and the court order required that all exhibits be submitted by September 23rd. And I don't understand what the purpose of the transcript would be. So I would object.
Very simply, prior inconsistent statement. It was vetted through by the rules of evidence. It addresses the exact and every topic, and it would help expedite this to go along smoother, Your Honor.
Mr. Hikes, first of all, you can be seated. I appreciate your respect in standing up, but you need not stand up to address me in this matter. The burden in presenting a defense on this matter is yours. And if you anticipated that there was going to be testimony from Mr. Morales that would differ from testimony that he might have offered at the time of the grievance committee hearing, the burden to pursue that is yours. And now at this late stage, you're asking for all of the proceedings to suspend so you can, I presume, ask the state, the Office of Chief Disciplinary Counsel, to provide that transcript. And that simply is not the way that you should pursue the matter. So I'm not inclined to grant your request. But we have another issue. I have a hearing scheduled at noon today. It's quite clear that this hearing is going to take significant time. And it also seems to me that the hearing would be better off if it were conducted in person. So I'm really reluctant to inconvenience Mr. Morales and Mr. Capellas. We can certainly allow them to testify remotely, but I think at this point, I'm going to suspend the hearing for today. I'm going to reschedule it for an in-person hearing in Waterbury at a date which will be selected at some point within the next day or so. But Mr. Hikes, I'm going to remind you again, I know you know how important this is, and I understand that you have defenses that you feel you can't assert, but you have to assert those defenses. So you're getting some grace here today by the matter not going forward. I want to be sure that you will appear on the date that the matter is scheduled, and I want to be certain that you're going to be prepared to offer whatever defenses you have at that time and offer any exhibits that you might have at that time. We've just run out of time today. So, I'm sorry?
May I just rewind back briefly? I was asking the state if they'd be willing to stipulate to the admission of the prior transcript of the aforementioned hearing is my first thing. The second of all, Your Honor, I can, and I believe, get my hands on another copy of it if you would allow just later to consider it and me to ask it be introduced. And the second issue, Your Honor, is I'm out of state. I've been unemployed essentially since COVID, because I wasn't making much money during COVID before I got suspended. I am pretty broke, Your Honor, and I'm not sure how I could get myself up to Connecticut from 8 hours away. It would be a financial burden that I'm not sure how I'd pull off, and I do not want to disrespect your orders.
On the one hand, you are raising an issue about not having access to exhibits and not being able to offer exhibits. I'm giving you a vehicle by which you may do that. And this is, we're talking about your career here. And I think the best way for us to proceed is in person. That's to provide you with the greatest possible opportunity to defend yourself. I'm not insensitive to the issue that you're raising with respect to your inability in terms of financing to be able to finance a trip up here, but I think that in the interest of expediency and making sure that this is done in the most efficient way possible, I am going to continue the matter for an in-person hearing. We will work with you. The Office of Chief Disciplinary Counsel in the court will work with you on finding a date that works for you within the next several weeks, and we'll try to get it done.
Your Honor, can I please have a date certain by which all exhibits must be filed?
Yes. 2 weeks from today, all exhibits that are being offered by Mr. Hikes must be filed with the court.
Thank you, Your Honor.
All right?
Your-
Yes, sir. Sorry, Mr. Hikes?
I'm sorry, I was just writing your 2 weeks order down.
Okay,
for
okay,
My recollection.
all right.
I'm just going to be straight with you. I understand that my disbarment is coming. I don't know how I'm going to be able to get up there, and then that would, and I'm not sure how I'd be able to get my hands on a transcript without being up there personally within 2 weeks. I just don't see this going any feasible way. So why delay the inevitable?
Well, I've run out of time today in any event. So
Communication. I don't like the illegal trespassing on a dead woman's property. I don't want to be bothered by this and all anymore.
Hmm.
If you read the transcript, Your Honor, I think it would be pretty enlightening.
Well,
I ain't in the tip of the iceberg because I got to respect attorney-client confidentiality on a lot of other people. Defense attorneys can't make a case into what the grievance thing. It's just well known, and it's well known that solo practitioners are targeted. Criminal defense attorneys are the lowest on the totem pole. I've come to terms with it, Your Honor. I'm going to take it as a man.
if you've come to some conclusion as to how you want this matter to resolve, I would suggest that you speak with the Office of Chief Disciplinary Counsel to see if some type of an agreement can be reached. My experience with them is that they're very reasonable. They're willing to listen to whatever it is that you have to offer. So by continuing the matter for a period of time, that will give you an opportunity to do that as well, or in the alternative, to make arrangements to present your defense to the matter. So at this point, we're going to stand adjourned. If you want to stay on the line, Mr. Hikes, with Attorney Villar and the court to try to establish a date, fine. If not, we will go ahead and set a date in any event. So I'm going to conclude the matter now, and I'll be back, Mr. Ferraro, for the next matter in 10 minutes. All right?
Your Honor.
Stand adjourned.
Thank you, Your Honor.
So we're not going to see them again for two reasons. For two reasons. One, he made it the next hearing in person. Two, we're not going to get to the next hearing. If we do, he's not going to show up, but he's going to give up. He threw in the towel. He's just going to contact the disciplinary council and take he's going to get disbarred. So that poor guy, now he's going to have to find a whole nother career. The Judge Fleischer says Amazon is a really good place to work. Or he could go to Georgia and work for Coca-Cola. Personally, I would work at some place that makes food, because you can always eat if you work at some place that makes food. You get bored of the food, but you at least always have food. Or, no, don't work in a bar because that's too much alcohol. I thought he was in trouble for alcohol. I thought that's what the case was about. I read the complaint that put him where he is, and I thought I saw alcohol. involved. And we didn't get to hear all the testimony, so maybe we just didn't get to that part yet. But we won't now. It's over. He lost his license. Guys, I know a lot of you probably don't catch my streams because they're at 4:30 in the morning, but thanks for coming out for this video. I really, really appreciate it. And behave. I'll talk to you again some other day. Bye, guys.